After arrest and first appearance, your case will be scheduled for an arraignment. Today we're going to take you out of the crowded courtroom and discuss what happens at an arraignment. An arraignment is a court proceeding where you are presented with the formal charges against you. This will be in the form of an information, or in rare cases, an indictment. The information is a document that tells you the offense you are alleged to have committed, when you are alleged to have committed the offense, and what statute you are alleged to have violated. At the arraignment, you will be told the substance of the charges against you, and you will be asked to plead to those charges. You can plead guilty, no contest, or not guilty. If you plead not guilty, the judge must give you a reasonable time to prepare for trial. The judge will also advise you that you have a right to an attorney, and if you can't afford one, an attorney will be appointed to you. The arraignment is the beginning of the case, not the end. Unless you have thoroughly consulted with an attorney, you should never plead guilty or no contest to any criminal charge at the arraignment. Some criminal convictions come with very serious collateral consequences that you may not have considered. For example, some convictions can cause your driver's license to be suspended, the loss of federal benefits, the loss of your job, the inability to rent an apartment, deportation, and many other collateral consequences. There may be alternatives to pleading guilty or no contest at arraignment. For example, your attorney may be able to file a motion to suppress or a motion to dismiss, or have your case sent to a pretrial diversion program. If you plead not guilty at arraignment, you can still change your plea later. However, if you plead guilty or no contest at arraignment, you will not be able to later withdraw your plea and fight the charges, except in very, very limited circumstances. There may be times when you do want to plead guilty or no contest at arraignment. This should be done only after thorough consultation with your attorney. One situation where this may be beneficial is if you are given a generous short-term offer by the prosecuting attorney and the evidence against you is strong. For example, if you were charged with a crime with a minimum mandatory sentence, the evidence against you was extremely strong, and the prosecutor agreed to a plea agreement well below that minimum mandatory offer. Any plea of guilty or no contest at arraignment should be extremely rare and only after careful consideration with an attorney. Sometimes you won't have an arraignment. The rules allow the arraignment to be waived if your attorney files a written plea of not guilty. Whether the arraignment is waived is within the discretion of the judge. If the judge doesn't waive the arraignment, he or she may still waive your appearance at the arraignment, allowing your attorney to go on your behalf. Make sure you ask your attorney if you have an arraignment and if you are required to appear at that arraignment. If you can't afford a lawyer, the judge will appoint you a public defender. If you can afford a lawyer, but you don't have one by your arraignment date, the judge will give you time to obtain a lawyer. You can simply tell the judge that you would like to retain an attorney, and the judge should pass your arraignment to a later date. Sometimes the judge at first appearance will set a bond that is too expensive for you to post. If this happens, your attorney can file a motion for a reduction of your bond and have the case placed on the judge's calendar for a bond reduction hearing. This bond reduction hearing may happen before, during, or after the arraignment, depending on when the judge decides to hear the motion. At the end of the arraignment, the judge will pass the case for a pretrial hearing or for a trial date. This is a general discussion about arraignments, but make sure you discuss the arraignment process with your attorney to ensure you understand and comply with how arraignments are handled in your jurisdiction and by your particular judge.